Hello YouTube, I'm Vince White. I'm an employment attorney. On this channel, we answer publicly posted questions from YouTube users, getting folks the answers they need from an employment attorney. We got a question here from YouTube user IM1066, who said to us, let me read it here. Let's scroll down. I'm currently in the process of discovery, and my former employer is asking a bunch of not only irrelevant questions, but questions I could simply answer no. For example, they are asking me to list all the litigation I've been involved with over the past 5 years. The answer to that is none. But it's also relevant to my claim of being retaliated against by my former boss. The agency is playing the usual delay and ask extraneous questions during discovery tactics, so I'm wondering if it is reasonable for me to object to this rather than answer it simply to let them know I'm not a pushover. Or should I take the path of least resistance and simply answer no to questions even if they are irrelevant? So I don't want to be obnoxious, but that's inherent to my personality. The court and the other side are not necessarily going to agree with you about what is and is not relevant. I hate baseball and I don't think it's a sport, but we're going to make a baseball analogy because it popped in my head. You know how umpires have like a batter's box? It's really discretionary as to what is and is not a strike. And people tend to have a feeling for different umpires and their mental discretionary imagined batter's box, right? And listen, do umpires mess around with the batter's box to change the course of baseball games? Maybe. I don't know. I also don't care. It's not a sport. It's a game at best. But except for the pitchers are real athletes. That's a hard job. But listen, if you can be as fat as me and play baseball professionally, you're not an athlete. It is what it is. I kid. I'm serious. But I kid. That discretionary box, that strike box, different people have different ideas about how broad it should be, how high it should be, all kinds of things, right? So too do judges, arbitrators, court attorneys, and litigators in our field. And you, as I think a pro se litigant, I'm not sure, you didn't specify that, but it sounds like you're not an attorney. This might be your first time litigating in our field. And that's amazing. Well done. My hat's off to you. But because it's your first repetition in this field, you may not have had the same opportunity to grow together with the field in what the field generally thinks is relevant. Am I saying that their question about your prior litigations is absolutely irrelevant? No, I can see arguments both ways. But I do think a lot of judges, not all, but a lot of judges would say, just answer the question. So is it worth your time to object? Probably not. I would save your objections for things that matter. Discovery scuffles going both ways, refusing to turn things over or trying to force the other side to turn things over. They're a good tool to grind the other side down and cause grief and trauma and, well, not trauma, but cause difficulties in the litigation and extra expense, right? But generally use them where you have a meritorious argument and an actual reason for wanting the result you're fighting for. Because I'm sure you may have noticed when you're causing extra legal work for the other side, you are also almost certainly causing extra legal work for yourself. Now, when you're represented by a plaintiff side attorney, that may not matter as much because you probably don't pay your attorney by the hour. And defense counsel generally are paid by the hour, often $1,100 to $1,600 an hour. So, that's a pretty good deal for the average plaintiff. Here, if you're representing yourself, it's your hours. It is hours of your life being stripped away at something you were not as experienced at as everyone else involved. So everyone else is going to do it faster and possibly more effectively than you. Not because they're smarter than you, just because they've had more repetitions in this field. And they tend to know what judges and arbitrators, administrative law judges and mediators will all expect to see in terms of arguments and what will and will not necessarily carry the day in terms of a legal argument for, a motion to fight some issue in discovery or a motion to compel some issue in discovery, whatever it is. So make your fights count. Your time is valuable. Your time as a pro se litigant will be used up extravagantly. It will be a detriment to your quality of life for the next year and a half at a minimum. At a minimum, if the case is going to make it to trial. And so pick the fights that matter. That may be difficult because you don't do this for a living, but you seem very savvy. I feel like you're going to have a really good ability to decide which fights matter to you and to your case, which fights will reduce risk for you or add value, right? That's really the metric. And I would strenuously, really push you to only burn those hours of your life when you need to. Because as a plaintiff, whether you represent it or not, you need to be considering your well-being, and you might be a very strong person. I don't know. Listen, everybody who fights an employment litigation case is a strong person in one way or another because they are standing and fighting, and less than 4% of victims do that, as far as we can tell. So, but that being said, you might be very strong. You might feel that you have unlimited well-being to throw at this. The most seasoned, hardened attorney, the most mentally unwell attorney who has deep-seated character flaws that make them comfortable in high-conflict environments, whatever it is. The person who does this every single day of their life, 7 days a week, eats fire and spits client checks, right? Like that's whatever it is, right? That person should still treat their well-being as a slowly regenerating resource. And I will bench attorneys who I think are not doing that. Because if you're not taking care of your well-being as a pro se litigant, as a plaintiff, or as an attorney on the plaintiff's side, you are degrading your ability to make decisions. And the ability to make decisions is how cases in this field are won. You have many hundreds, if not thousands, of decisions to make as a pro se litigant. Decision fatigue is a real thing, and the quality of your decisions will falter if you are not properly rested, if you're not getting proper nutrition. Even things like vitamin D really matter as far as we can tell. All of these things matter. And the clients, the pro se litigants, and the attorneys who say, nope, doesn't matter to me, I'm going to go fight it. Somebody should put you on the bench. You can't fight forever. As far as I know, no human can just fight endlessly. To the best of my knowledge. Maybe there's someone. Love to meet them. No, I wouldn't. Actually, I say that. I don't think I would like to meet them. That person doesn't sound very human. Also doesn't sound very pleasant. I can fight forever. It doesn't hurt me to fight with people endlessly about hate crimes. Okay. That's very useful for an employment law firm, but you must be hell at parties, right? Like, I'm good. I'm all right. So this is a very long way of saying, fight the fights that matter. Fight the fights that you need to fight to make the case turn into money for you. Turn into a big win. I would take the path of least resistance where you can and go down swinging on any motion that matters to your case, And the standard for matter is, right, the standard for what matters to your case is, does it add value? Could your case be potentially more valuable, or does it reduce risk? Does it make the chance that you lose lower? That's what matters in employment litigation. Anything else is wasted effort that will take time away from your rest and rehabilitation of your general well-being. I am 1066. I hope this is helpful. It sounds like you're doing a great job. I hope you're victorious. I will be cheering for you. I hope you get that fat check, whether it's by settlement or award, whatever means necessary. I hope you get paid. And I hope what was done to you is made right and that you are made whole. If anyone disagrees with me, please comment down below. And if the video was helpful, like, subscribe, and comment down below. Share the channel so it can grow. Take care, everybody.